Hi, I'm Janet Payton. I'm a partner with McGuireWoods Intellectual Property Group, and I'm a member of our data privacy and security team. Welcome to Season 4, Episode 3 of our Frenemies series. Don't worry if you haven't seen the other episodes yet. You can watch them in any order. Today, my partner Mebs Dosa from our London office and I are going to talk about GDPR. GDPR has become a really scary term for a lot of folks in the marketing world. This short episode is not intended to make you an expert on it, but we hope that it will give you a little more clarity about what it is, when it applies, and when you should consult an expert. If you've watched our other episodes, you know that our Frenemies theme is based on the idea that sometimes the lawyers and the marketing team are not always on the same page. There are a lot of myths out there about GDPR, and the best way for marketing and legal to get on the same page, and maybe even become friends, is to have a basic understanding of what GDPR is and what it isn't. So with that, here are 10 simple things that you should know about GDPR. Number 1, Europe takes privacy much more seriously than the United States does. This is just a simple fact, not trying to throw shade, but there's a stark difference between the way Europeans think about privacy, especially when it comes to personal information. The EU mindset, and when I talk about Europeans, I'm throwing in the British here too, notwithstanding Brexit, believe that an individual's right to control their data and who has access to it is a fundamental human right. By contrast, in the United States, except maybe California, and see Season 3, our episode about California privacy law, we've generally taken the opposite view. If I collect the data, it's mine. You've probably heard the phrase, possession is 9/10 of the law. That's how we always operated. I can use it and share it with my affiliates and my business partners if I want to, and once I have it, I'm really free to do whatever. This state of affairs is horrifying to Europeans. Their law is built on the assumption that if you share your data with a particular company, they can only use it for the purpose for which you shared it and no other purpose. And if they're going to allow a vendor or an affiliate to access it, they are also bound by whatever that original purpose was. If a company is going to use it for marketing purposes, they have to get affirmative consent from the individual. And if the individual later changes their mind, wants their information to be deleted, or wants to understand what information you have about them, or doesn't want their information shared with third parties, those wishes must be honored. Every company that is subject to GDPR has to follow these rules and has these obligations with respect to the individual who shared their information. All data on their servers, whether it's employee data or customer data or any other kind of personal data, falls within the scope of this law. Number 2, GDPR might apply to you even if you've never set foot in Europe. Let's let that sink in. A lot of people misunderstand and think, I'm not in Europe, so GDPR doesn't apply to me. It's just not true. There are several different ways that you might be subject to GDPR. One is if you have an establishment in the EU, and that's the one that's sort of intuitive. If you physically are present in the EU, you have business operations there, you have employees working there, anything along those lines, even if it's sort of temporary, if you're over there, you're subject to GDPR. But even if you're not over there, you could still be subject to it if you're offering goods or services to people in the EU. And then there's actually another way, which is less likely, but it could come up in certain circumstances if you're monitoring the behavior of people in the EU, like monitoring their online behavior or somehow tracking them. That one can apply also. Number 3, what does it mean to be a controller, and is my company one? This is a really important concept under GDPR. A controller is the party that is sort of in charge of the data, Typically, it's the party that originally collected the information from the EU individual, or it's the party that the EU individual thinks of as their counterparty. It's the one that they originally shared the information with. They know who has their data. It's company A, and that company is typically the controller. For example, if an individual in the EU hires McGuireWoods to represent them and provides us with their personal information, then McGuireWoods is the controller. The controller has some very significant responsibilities under GDPR. As a controller, we have a legal responsibility to care for the individual's information for them, to use it only for the purpose for which it was obtained, to keep it safe, and to disclose to the person what we're going to do with it and with whom it's being shared, so that they can have choices about what they do with their information, and they can tell us what they're allowing us to do with it. The disclosure part is the privacy policy, and we're going to talk more about that in a bit. The controller has almost a fiduciary type responsibility. They get the data and they have to be responsible with it and keep it safe and share it carefully and do whatever the data subject said and nothing else. The controller is sort of the owner of the data for those purposes, for the purposes for which it was collected, but the controller can't use it for any other purpose without permission. Number 4, what does it mean to be a processor, and is my company one? Processors are typically parties that use the data at the direction of the controller. They're usually vendors. They don't have any ownership rights, and they can't do anything except what the controller authorizes them to do. Generally, they're a vendor that was hired by the controller to perform a certain specific function. For example, a controller might be a retailer who sells products online, but because they don't want to be in the payment card business, they outsource the payment processing to a processor. And the processor does only what the controller tells them to do. They process the credit card purchases from the retailer's customers, but they can't do anything else with the data they collect. They can't use it for some other purpose. They can only use it for the purposes that the retailer/controller said they could. Controllers have to bind their processors by contract, and those contracts spell out exactly what they can do. And they also spell out whether or not the processor is allowed to hire any sub-processors, or we would maybe in the US call them subcontractors. Those have to be approved by the controller, either in advance, or they have to authorize the processor to allow sub-processors and be audited about that, so that they can at any time have notice of who the new sub-processors are and approve them. GDPR has also imposed strict obligations on processors. So there are some direct obligations under GDPR that processors have to follow.
Thank you, Janet. I'm Med Stoss, as Janet mentioned. I'm a partner at McGuireWoods, and merger and acquisition lawyer, and also specialize in compliance in data privacy, in particular EU data privacy, that Janet has given you a very good introduction to. What I will also want to mention to you is that if you think GDPR is complicated and has made your life difficult, then there are other laws in the EU that you need to be aware of, especially if you're involved in marketing. One of the key legislation that all marketing folks should pay heed to is the e-privacy regulation. They sit side to side by GDPR, and they give individuals specific and businesses specific rights in relation to electronic marketing. So any marketing that you do electronically, you have to make sure that you comply with the e-privacy regulation. So what do they say? Well, e-privacy regulation says that there are certain requirements that you must follow before you can utilize personal data for marketing purposes. Now, you might think, I'm the company, my customers have given me personal data, and I want to sell things, I want to tell them about different things that the company is doing. I should be entitled to send those information. Well, in the EU, the law says, no, you can't until you comply with certain regulations. In addition to that, the law in the EU says that you must, in certain circumstances, where for marketing purposes, you are going to track individuals' behavior in terms of how they are reacting, what they are buying, how they are navigating your website, so that you can utilize that data to target certain products and services to them, then the law says you must first get their consent. Well, that is not easy to do, especially in our world where technology, especially things like cookies and similar form of technologies, are essential part of marketing tools. But you cannot just simply use them. You must get consent. And marketing people, I know, get really frustrated with different requirements in terms of should the consent be opt-in, should the consent be opt-out, do I have to give the individual choices in terms of when I can do certain things in terms of the information, in what way I can follow their behavior? Yes, all those you have to comply with, as complicated as they may be. And it is important that you get consent. And this is where, again, we go back to GDPR. GDPR says, in order to get consent, you must make sure that consent for marketing purposes is given freely, and it is informed, and it is unambiguous. What does that mean? It means you must give individuals full information in terms of how you intend to use their data for electronic marketing purposes before you get their consent. And their consent must be some form of affirmative action so that you know they have agreed to those terms. So, number 6. Well, GDPR also says that you cannot transfer data from the EU, UK to the US. Now, that must be very complicated in a global world where businesses are scattered. There are different offices around the world, branches, branch companies, subsidiaries, and also in a world where your service provider might be based in one part of the world whilst you're based somewhere else. Your customers will be scattered around the world. Transfer of data is essential for any global business for marketing purposes. But what GDPR says is that for data in relation to individuals who are based in the UK or the EU, you cannot transfer their data outside the EU, UK to any other country unless that other country has similar protections as provided by GDPR to protect those individuals in terms of the use of their data. That is complicated. What the EU has done is it has identified a list of countries which it considers to be safe countries where they consider the laws are sufficient enough to protect individual data. So if you want to transfer data to those countries, that's fine. But in relation to all the other countries, you have to put appropriate safeguards. Now, when it comes to transfer of data from the EU, UK to the US, there is a problem. You cannot transfer data to the US because the EU regulators consider US not to be a safe destination because of the laws in the US in terms of protecting individuals whose data is transferred to the US. So what can you do? There are other mechanisms that are available where you can put in place in order to safeguard those requirements. One of those is putting in place what we call standard contractual clauses. These provide that any person who sends data from the EU, UK to the US, and whoever receives that data should ensure certain protections in relation to the data, how it's used, for what purpose it can be used. It will specify that you cannot use it for any other purpose than it was sent to you. There are certain instances where if there's a data breach, you must notify the person who has sent the data to you from the EU, UK to the US. So you have to comply with those requirements. They have quite stringent rules, and recently we had an EU judgment which has said transfer of data to the US is of a general concern. So it's very important before you transfer data from the EU to the US, you put in place safeguards, additional safeguards to make sure you're complying with GDPR. So yes, GDPR imposes a lot of obligations on, as Janet mentioned, on controllers, on processors, but in addition to that, the core purpose of GDPR is to protect individuals whose data it is that is being used by businesses, by marketing people. And what GDPR has done is it has enshrined in law certain rights for the benefit of EU data subjects. So people who are resident in the EU, if you're processing their data, they have certain legal choices. They can ask you to stop using their data at any time they want. They can ask you to have access to any data you hold for any purpose, irrespective of how and when they have given you the data. They can ask you to ensure that any data you hold on them or for them, that data is up to date. And if it is not up to date, it should be made and brought up to date. So that is a legal requirement that you must follow. Giving other rights in terms of if a data subject has given you consent to use their data for marketing purposes, they can withdraw that consent at any time. So as soon as they notify you and say we are withdrawing our consent, you must stop using their data. That is an EU data subject's basic right, and that is enshrined in GDPR. It's very important that you respect those rights and are conscientious and make sure that if a data subject has made any notification in terms of how their data needs to be used, then you must tell them. And there are certain legal requirements where if a data subject tells you they want to know what data you hold on them, you must respond to them in a timely fashion. So moving on to the next requirement. A fundamental part of GDPR is letting people know what data you will be collecting and how you're going to use that data. And that must be done at the point you collect their data. Not afterwards, not as an afterthought, but at the time you collect their data. So it is very important that when you have your privacy policies, you ensure that you inform data subject of certain minimum things that GDPR requires you to notify them at the point of collection. Some of those examples are that you must tell them the types of data you will be collecting, even if it's not obvious, even through electronic means, through cookies, through other technologies, you must tell them what data you're collecting, how you will process that data, the purposes of processing the data, and GDPR says you have to have legal grounds to process that data. You must specify how you're going to process the data, on what legal basis. You must also let them know how long you will retain the data. So for example, if you're selling some information and you collect an individual's data, you must let them know that after you've sold that item, how long you're going to keep the data and why you need to keep the data for that duration. If you're going to be sharing the data with other service providers, your group companies, you must tell data subjects that you will be sharing the data and how you're going to be sharing the data. It is very important that if you're collecting data for marketing purposes, that you let them know that you will be using that information for marketing purposes. If you are going to collect data for marketing purposes and selling that information to other third parties for marketing purposes, you must let them know and you must get consent from them. It is very important that you do so. And there have been a lot of case law here in enforcement action where marketing information has been collected and used for marketing purposes without the individuals being told how that information is going to be used and appropriate consent being obtained. So why is GDPR important? Yes, it is quite an inclusive law in terms of telling you how data should be processed. But it is more important because GDPR imposes extremely high fines for non-compliance. The basic requirements for GDPR is that if you are in breach of any basic requirements of GDPR, the regulators in the EU can fine you up to 20 million euros or 4% of your global turnover. So not your local turnover, not your EU turnover, your global turnover. That can amount to large numbers. Well, in reality, they have amounted to large numbers. If you look at the last 12, 18 months, EU regulators have utilized the rights they have under GDPR to fine companies who they consider are not complying with GDPR. And a lot of that non-compliance has been in relation to companies utilizing data in relation to individuals for marketing purposes. So I'll give you an example. CNIL, which is the French regulator, fined Google $58 million for lack of transparency, not letting people know how they are going to use that data, not getting consent from users in order for collection of data for purposes of using for marketing purposes. Another example is Italian regulators. They have fined quite substantial amounts for breach of data privacy rules, in particular for marketing purposes, electronic communications. So it's very important that you heed the requirements of GDPR. In addition to that, GDPR regulators have also fined people in relation to non-compliance for cybersecurity attacks. And it is very important that you comply with GDPR in its entirety, so that if you are a subject of a cyber attack and you lose your data, then at least that the regulator is cooperating with you and will not unnecessarily fine you large amounts because you are generally in compliance.
Thanks, Mabs. And here we are at the number 10 thing to know about GDPR. You've heard quite a bit tonight, and hopefully you've come to this conclusion, which is that McGuireWoods knows GDPR and our lawyers can help you. It's really a lot for anyone to handle in-house unless you have an EU privacy expert on your legal staff. So don't hesitate to reach out for help if you think that you might be subject to GDPR. We've got a deep bench here in the UK and in the US, and we have a great blog that updates on all kinds of privacy-related issues. It's called Password Protected, and you can find it at www.passwordprotectedlaw.com. So thanks for watching. We appreciate you joining us for this episode in our Frenemies series. We hope it made GDPR a little less scary. You can, of course, reach out to Mebs or to me for additional information, and we'd be happy to assist. As I said, this is the last episode in season 4 of our Frenemies series, but don't worry, there is still one whole new season. During season 5, brand new information, 21st century advertising issues, our colleagues Amanda DeFord and Lucy Wheatley will present on social media, the FTC, fake reviews, and domain spoofing. So join us then. And in the meantime, don't forget, all the previously released episodes of Frenemies can be accessed on the McGuireWoods website for on-demand viewing. Here's our contact information. Don't hesitate to reach out to us if we can help you. And again, thanks for watching.